So the war's over in April, May 1865. You're still states. You're merely in rebellion to lawful authority. And we see that the 13th Amendment abolishing slavery was ratified December 6, 1865. Georgia voted December 6, 1865. Is Georgia considered a state in the Union on December 6, 1865? Can only member states participate in amending the Constitution? I mean, you got to be a full-fledged member. I mean, did we send it to the provinces of Canada or a foreign country? Hey, you want us to amend this? No. It goes to member states. We're back in the Union, December of 1865. Peace is declared by presidential proclamation, April 2nd, 1866. So now peace is declared. The war is over. 1865, 1866, the war is over. 14th Amendment is proposed by the 39th Congress, June 13, 1866. And is rejected by all southern states except Tennessee, and there's the dates out. What's the 14th Amendment? It's the nationalization of citizenship. It's taking away state sovereignty, takes away all your state citizenship, and it makes you a citizen of the federal government. So we're the federal government. This is what we're talking about in Federalist 39. That's what the 14th Amendment does, and we're going to actually read that in just a little bit. On March 2nd, 1867, the first Reconstruction Act was passed by Congress in times of peace over the President's veto, declaring that no legal governments exist in any of the former Confederate states, except Tennessee. Congress proposed the 14th Amendment was going to nationalize citizenship. All the southern states rejected it, with the exception of Tennessee. They were pretty much coerced into it. And they didn't have enough of the northern states to get it passed either. This was not going over unanimously in the North, so don't think that. The Reconstruction was based upon the principle of Congress's power to conquer and subjugate the southern states' form of government and their citizenry. Okay, the Reconstruction Act was based upon the principle of conquest, clearly stated on the House and Senate floors. Where do you get the authority to annul a state? How many people read the Constitution? Is anywhere in there that says that Congress is given the authority to annul states, create new states, force them to vote one way or the other, or do anything of that nature? Doesn't say it in there. What's the Reconstruction Act say? Was Georgia in the American Union in December of 1865? Voting to abolish slavery. They were a member state. 1866, when the 14th Amendment was proposed, it was sent to these states. Georgia right here voted against it in 1866, November of 1866. Were they considered by Congress, member states of the American Union, when Congress sent it to them? Absolutely. Congress recognized them as being states in the Union when they sent the 14th Amendment to Georgia. You're a member state, here it is, vote on it. But when they voted against it, Congress instituted the Reconstruction Act, which said we're going to annul you. You're not a state in the American Union anymore. You're a mere territory. And we can do with you as we please. And we can put conditions on you to come back in as a member state of the American Union. That's the Proclamation of Peace. Let's just talk a little bit about the Reconstruction Act. We're going to look at the Reconstruction Acts and see if they're unconstitutional. Because this is the act that annulled the original state of Georgia. The state that's in here now is not the original state of Georgia. An unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Therefore, an unconstitutional act purporting to create an office gives no validity to the acts of persons acting under color of its authority. Unconstitutional act. What does it create?
Nothing.
Does it create an obligation? No. Does it create a duty?
No.
Does it create offices?
No.
Does it confer rights on people? No. Does it take away rights from people?
No.
No. It's a nullity. It doesn't do anything. An unconstitutional act is null. What gives an unconstitutional act life?
Power.
Recognition that it's not unconstitutional. Participating in it. saying, well, the unconstitutional act creates this, well, that's unconstitutional, but I'm going to give it life by participating in it. It gets life by participating in it, by recognizing it, by not participating in that which is lawful. Here's a copy of the Reconstruction Act. We're going to read a couple phrases out of that. I want you to look at, y'all know the Constitution? Does Congress have the authority to do any of this? Declare. This is just a declaration. Whereas no legal state government or adequate protection for life or property now exists in the rebel states of blah, 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 Georgia, does Congress have the authority to just decree? State government's gone. That's the very first sentence of the Reconstruction Act. It's a decree. Based on what? Do we have a right to face our accusers?
Yeah.
Is there something Georgia did? Okay, what's a bill of attainder? Garland talked about it earlier. Bill of attainder is, it comes out of the Crown of England, where the Crown would just declare a group of people guilty. They're outlaws. You can go kill them, you can do what you want to with them. A bill of attainder is declaring a crime, a group of people has committed a crime, punishing them for the crime, and there is no due process of law. They do not have a right to face their accusers. Georgia is, it's claimed that their state government is not a government for adequate protection of life or property. Did Georgia get to present witnesses in their favor and say, yes, we do? This is a bill of attainder right here. That wording right there is a bill of attainder. It's a decree. They committed a crime. It is the punishment. You are reduced to a territory, and it was not done in due process of law. But it says what they intend to do here, and whereas it is necessary that peace and good order should be enforced in said state until loyal and Republican state governments can be legally established. Oh, they want a loyal government to Washington.
Yeah.
Not loyal to the people of Georgia, one loyal to Washington, to Congress. So they want to put a loyal form of government, give a Republican form of government to people loyal to Congress. Is Congress worthy of loyalty at this time of our history?
No.
No, they're not worthy of loyalty. Section 5. And be it further enacted that when the people of any one said rebel state shall form the Constitution of government in conformity with the Constitution of the United States in all respects, and when said state, by a vote of its legislature, elected under said Constitution. Now let me explain what's going on here. Congress annulled the state of Georgia. They said, now, we're going to change the body politic. You know, the people who can participate in government. If you participated in the war, you can't vote. Okay, this is not your government. We're looking for loyal people. You weren't loyal. If you had an oath and violated, you weren't loyal. You know, you can't vote. You can't participate. We're going to say that anyone born in the United States living in Georgia can vote. This is where carpetbaggers came from. People from the northern states were coming down and organizing stuff. Now they're the citizens of Georgia, of this new Georgia being created. Anyone born in the United States is the new Georgia. And it says they have to, this new body of people has to create a constitution. They shall have adopted the amendment to the Constitution of the United States proposed by the 39th Congress and known as Article 14. Okay, they got to have a constitution, send it to Congress. You've got to bring up the 14th Amendment, and you are required to pass it. Not vote your conscience, you're required to pass it. Is that a vote of conscience? No, it's force. It says, and known as Article 14, and shall have adopted the amendment, they're required to adopt it, the 14th Amendment, and when said article shall become part of the Constitution of the United States, said state shall be declared entitled to representation of Congress and senators and representatives. Georgia, you're not a full state until you adopt the 14th Amendment. Oh, no. You're not a full state until you adopt the 14th Amendment and it becomes part of the national legislature, the national constitution. The purpose of Reconstruction is to coerce, right there's the word. Is Congress authorized? Is this the amending process? How many people read Article 5 of the Constitution, how to amend the Constitution? Is annulling states and forcing them to adopt it under military rule, and you don't have representatives in Congress until you adopt. Is that part of the amending process? That's what we're living under, people. This little time frame of our history destroyed everything we got, and it's so perverted in the education system and in our minds. It's real easy to read these words. They don't run from us. These are the actual words. Is Congress authorized to do this? Force a body of people to adopt an amendment to the Constitution? Is that unconstitutional?
Yes.
Absolutely. But this created the state of Georgia that's in place.
Don't you ask people?
Yeah. This is what created the state of Georgia that's in operation today. This unconstitutional act. Yes, sir.
How can it still be a state when it was no longer a state, so that it could vote on it, to be then included in Congress?
It's absurdity.
Yes.
This is an absurdity in law because they're not really a full state. A state has senators and representatives, and when you read the amending process, I think it's about the only stipulation of what can't be done to a state during the amendment process. They cannot be denied representation in the Senate. Is Georgia denied representation in the Senate? Were they considered to be a state prior to this date? Yeah, they were considered a state of the Union. But on this date, March 2nd, 1867, the United States of America was national. And we went from a federal government with limited national powers to a national government with solely, total national powers. And that's easy to say, but I'm actually going to prove that too. Proverbs 22:28. Do not move an ancient boundary stone set up by your ancestors. What I'm talking about is, who owns the property of Georgia? The people it was stolen from by Reconstruction. And it was given to a new group of people that Congress likes. Somebody moved the boundary marker and says, this property isn't yours anymore. Deuteronomy 19:14, you shall not move your neighbor's landmark, which the men of old have set, in the inheritance that you will hold in the land that the Lord your God is giving you to possess. Now I know this is talking about Israel, but the general principle is you don't steal someone else's property holds up. Andrew Johnson vetoed all the Reconstruction Acts. Here's what he said in one of his vetoes. Another ground on which these Reconstruction Acts are attempted to be sustained is this, that these 10 states are conquered territory, that the constitutional relation in which they stood as states toward the federal government prior to the rebellion has given place to a new relation, that their territory is a conquered country and their citizens are conquered people, and that in this new relation, Congress can govern them by military power. What was the object of the war not for? What did those Union soldiers fight and die for? It was not for conquest. What is Congress making it? Conquest. It says a title of conquest stands on clear ground. It's a new title acquired by war. It applies only to territory. This is the Reconstruction Act is a transfer of the title of the soil of Georgia to the United States government as conquered territory that they get to do with as they please. That's why it became a territory, and they populated it with loyal people to them. Was the Constitution of the United States designed for loyal people? No. It's designed for the states as sovereign bodies to do what they want, not loyalty to Congress. Andrew Johnson went on. There's not a foot of the land in any one of these 10 states which the United States holds by conquest. How does he know? He's the commander-in-chief of the armed forces. He knows what the military did. And if Congress has an act out there that says, a resolution that says the object of war is not for conquest, did he have any legal authority to conquer states using the military? No, it would have been a usurpation of power. He couldn't have. He was forbidden by the intents of Congress in the original objects of the war. We didn't conquer it. Who conquered the states? Congress conquered the states. The 39th Congress conquered the states through legislative action, the passage of the Reconstruction Act. But he says this, what are we about here? Remedy. The remedy must come from the people themselves. And this is in his veto of July 19th. The remedy must come from the people themselves. They know what it is and how it's to be applied. At the present time they cannot. Says the remedy is nevertheless in their hands. It is to be found in the ballot and is a sure one, if not controlled by fraud, overwrought by arbitrary power, or from apathy on their part, too long delayed. With abiding confidence in their patriotism, wisdom, and integrity, and still hopeful of the future, and that in the end the rod of despotism will be broken, the armed heel of power lifted from the necks of the people, and the principles of a violated Constitution preserved. And this is said by America's least favorite president. Doesn't he always rank as the lowest, the worst?
He was the first one impeached.
He was impeached. He was impeached for violating the Tenure of Office Act. It was an act that says he could not remove anyone from his own cabinet without permission from Congress. A violation of separation of powers. He was impeached over an unconstitutional act. The act he was impeached for was later declared unconstitutional. It was not a law. Congress was just merely going after him because he was against Reconstruction. He was against all this. Where's the remedy come from? The people. This is on the Capitol grounds in Raleigh, of the 2.5 presidents from North Carolina. We got James K. Polk, Andrew Jackson, and Andrew Johnson. The reason I say a half is because no one knows where Andrew Jackson was born. He was born in a territory called the Waxhaws in between North Carolina and South Carolina, and no one knows where he was born. And so it's actually decided every year by a high school football game. Whichever team from the high school in those two areas wins, then they get the claim that year. So that's how our 2.5 presidents from North Carolina. But we have Andrew Johnson is from North Carolina. And it gives a little one-liner here about what these people were about. And it says, he defended the Constitution. How many people hear that about Andrew Johnson?
He was from North Carolina, but he served in Tennessee as a senator.
He moved to Tennessee, yes. He was a senator from Tennessee, but again, when states declare the birth, where presidents were born. He was born, I think, up in Wake County, Raleigh. What's he holding in his hand in this statue? Constitution of the United States. He defended the Constitution.
This term is drunk.
Oh, they want to vilify
Yeah, call name call.
political correctness and trash people's character, all those things they still use today, by the way. But it's up to us to decide what the truth is. Because if I don't know the truth, I'm only manipulated by what I don't know. I can be led to believe all sorts of things. Like, we can invade countries that supposedly have weapons of mass destruction that don't, then feel good about it and do nothing. Were the 14th Amendment and the Reconstruction Act designed for the freed slaves, or were they designed to nationalize citizenship? Let's keep going. There's a guy by the name of James G. Blaine. He was a congressman from Maine, so it's easy to remember. Blaine from Maine. Okay? We'll quote from two of his different books. One is his Political Discussions, 1856 to 1886, where he puts all of his speeches in it. And then his autobiography, 20 Years of Congress, 1861 to 1881. He was in Congress the entire war, was behind all this stuff. Remember, he loves Reconstruction. Okay, so he loves this overthrow. He loves it. But back then, they were more than willing to talk about what they did. They had no shame. This is in his speech August 29th. When was the 14th Amendment proposed? June 22nd, 1866. This is a speech he gave August 29th, 1866. So this is before all these states had voted against it or whatever, because they're creating this new status called a United States citizen. And it says, the 14th Amendment says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. A lot of people say, well, that's a Negro. It's one of the Negro amendments. It's designed to give blacks civil rights. It doesn't apply to all the white people. I mean, you'll still hear that today, that phraseology going on. But he made it very clear when he goes back to Maine and he's telling his people, what's the function of this 14th Amendment, this U.S. Citizenship Amendment? And he says that in making this extension of citizenship, we are not confining the breadth and scope of our efforts to the Negro. It is for the white man as well. We intend to make citizenship national. I mean, is that pretty clear? We intend to make citizenship national. In his book, 20 Years of Congress, where he's talking about this time period, he says, as the vicious theory of state rights have been constantly at enmity with the true spirit of nationality, because state rights means states have a right to do things. Nationality says the federal government trumps everything. They're opposed to each other. State rights and nationality are opposites. Remember what we read in Federalist 39? If you have a national government, they have control over everybody. You know, the sovereign states, they get to choose whatever they want as an individual state. It says it's the vicious theory of state rights. He hates state rights, 10th Amendment. Hates that stuff. Having constantly at enmity with the true spirit of nationality, the organic law of the Republic, which is the Constitution, should be so amended that no standing room for the heresy of state rights would be left. Had to amend it. Had to pass this 14th Amendment. Talking about the 14th Amendment. The first section of the Constitutional Amendment, which includes these invaluable provisions, is in fact a new charter of liberty to the citizens of the United States, is the utter destruction of the pestilent heresy of state rights, which constantly menace the prosperity and even the existence of the Republic, and is the formal bestowment of nationality upon the wise federal system which was the outgrowth of our successful revolution against Great Britain. That's a lie, the last part. Are these people who are players saying it was designed to nationalize citizenship? Nationalize the country. He goes on. He's talking about these new states that were created. Georgia, this new state created by Reconstruction, is what he's going to talk about. All these new states were ordained in the spirit of liberty. All prohibited the existence of any form of slavery. Well, slavery was abolished 2 years earlier, so what can they do about that? And all heartily recognized the supreme sovereignty of the national government as having been indisputably established by the overthrow of the rebellion which was undertaken to confirm the adverse theory of state rights. What did Congress tell these New York farm boys this war was to do? Preserve the rights. Preserve state rights, right? Preserve the states with all the dignity, equality, and rights of the several states unimpaired. What did they do with their victory? Lie about it. This is Thaddeus Stevens. He's one of the main ramrods of Reconstruction. He's out of Pennsylvania in Congress. He made this on a speech of Reconstruction, January 3rd, 1867. He hates the president, remember this. Though the president is commander-in-chief, Congress is his commander. He and his men shall learn this is not a government of kings and satraps, but a government of the people. And that Congress is the people. Congress is the sovereign. Congress is the sovereign, not the people. My red line rose up somehow or another when this thing got done. It's supposed to be on Congress is the people. When you read these words, who do you think? Do you think Congress?
No.
Congress is the people brings a new meaning to Lincoln's Gettysburg Address, that this nation under God shall have a new birth of freedom, and that government of the people, replace people with Congress, and that a government of Congress, by Congress, and for Congress shall not perish from the earth. That's just using his speech and Thaddeus Stevens' words. Who are we the people? It just depends on the meaning of the term, we the people. They're saying, you might be thinking one thing, somebody else thinking something else. Let's go back to that, James G. Blaine. It says, opening section of the 14th Amendment says, while conflicts and contradictions on this question, where does your citizenship come from? Does your citizenship come from your state, or does your citizenship come from the United States, the federal government, the national government? So it says, the opening section says, while conflicts and contradictions on this question, by a comprehensive declaration which defined national citizenship and gave to it precedence of the citizenship of a state. And all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. These pregnant words distinctly reversed the origin and character of American citizenship. Instead of a man being a citizen of the United States because he was a citizen of one of the states, he is now made a citizen of any state in which he might choose to reside because he was antecedently a citizen of the United States. The consequences that flowed from this radical change in the basis of citizenship were numerous and weighty. I believe that, Pastor.
Yeah.
Radical change. Because it changed the character, the origin. You're no longer a state citizen of Georgia. You're not a Georgian. You're a United States citizen. Our ancestors who fought from Great Britain were Georgians, not United States citizens. It's been flip-flopped. And then just go back to reading Federalist paper, the idea of a national government involves in an authority over the individual citizens and an indefinite supremacy over all persons and things. This supremacy is completely vested in the national legislature. Is that what we have today?
Congress is the people.
Congress, they're the people. They say because we're the representatives of the people, then we are the people. That's going to be their logic. But if you read the Federalist Papers, it says your representative can never substitute the will of those who he represents for his own will. State rights vanish without a trace, true fact, or an unsupported claim. Because nowadays we got people in the 10th Amendment movement. We got to get our 10th Amendment rights back. Have you been taught they're gone? You don't have them under this. That's the federal aspects of the Constitution that have been put aside. You do not have those. Think about it. Well, I'm going to talk about that later. On several occasions, the Constitution now, the Reconstruction Acts were attempted to be adjudicated. Hey, are these constitutional, unconstitutional? Every attempt has been met with obstruction of justice. Georgia, state of Georgia, Georgia v. Stanton, fighting against the implementation of Reconstruction. A bill to restrain the defendants who represent the executive authority of the government from carrying into execution certain acts of Congress, inasmuch as such execution would annul and totally abolish the existing state government of Georgia, is not within the jurisdiction of this court. U.S. Supreme Court case. U.S. Supreme Court is supposed to be this bulwark between the people and an over-encroaching Congress. Did they do a good bulwark job here? They just did a good bull job here. Ex parte McCarty. This is going to be the most interesting thing you've probably ever seen in your life. Highly recommend you pay attention, wake up if you have fallen asleep. McCardle was a editor of a Mississippi newspaper. In his newspaper, he wrote against this new Constitution. The Reconstruction Acts were forcing to have a constitutional convention and ratify and all that. He said this is all criminal, illegal. He was arrested by the United States military for impeding Reconstruction. If you remember, Lincoln suspended the writ of habeas corpus. Well, and it was pretty much still suspended. But the federal government had a problem with the suspension of the writ of habeas corpus. Once the states got to be states again, now what do you think they were doing to the collaborators and people that they didn't like? And they didn't have a writ of habeas corpus. Okay, were they being mean? Oh, probably quite. I'm sure they probably were being mean to them. But Lincoln had shut down the avenue to get to the Supreme Court. So they had to open it back up again so that loyal people could get there. They didn't want the unloyal people. They just wanted the loyal people to get to the Supreme Court. Who's supposed to defend the United States against a legal action against it, a suit against it? The Attorney General. The Attorney General defends it. Henry Stanberry was the Attorney General at the time. He's supposed to defend this. This is out of the New York Times. This is the case of McCardle arguments of Judge Black, that's Jeremiah Black and Senator Trumbull. And it says, in the course of the debate, Mr. Attorney General Stanberry defined his position. He said that a case had been laid before the president in which a military commission had sentenced a person to death. The question had been propounded to him by the president whether the condemnation and sentence were legal. He had, in accordance with his convictions, answered they were illegal and void, and had advised the president not to approve them. This being his opinion, he could not, of course, take the other side of the question. He said, I can't defend this. Therefore, he had declined to argue it here. He had left it to be argued by those who believed in the doctrine. He had given notice to General Grant in consequence of which other counsel had been employed. Basically, the Attorney General says, I don't believe in the constitutionality of Reconstruction, which I got to go defend. War Department, go hire yourself a private attorney. And they did. They hired a guy by the name of Lyman Trumbull. Who's Lyman Trumbull? Got a thing going here. He was a senator from Illinois. And Lincoln from Illinois. We have other problems from Illinois. This is Jeremiah Black. Jeremiah Black defended McCardle, saying Reconstruction is unconstitutional. Who is Jeremiah Black? Former Chief Justice of the Pennsylvania Supreme Court, former United States Attorney General, and former United States Secretary of State. Does he know the law? Being a former Attorney General, does he know federal law? Being former Chief Justice of the Pennsylvania Supreme Court, does he know state law? He knows what he's talking about. He's on our side. Okay? This is the guy fighting for us. And it just says that in the Supreme Court of the United States today, the McCardle case was argued on its merits. Mr. Jeremiah Black commenced the arguments in behalf of the petitioner who had been charged with and arrested for an alleged violation of the Reconstruction Acts. And he says, a state election was going on which was superintended entirely by the Army, which by means of bayonets drove one set of voters to the polls and drove another away from them. The whole thing was accomplished by naked terrorism. And when an unarmed and peaceful man expressed his opposition to such proceedings through his own newspaper, he was told he should not do so and was ordered into custody. He was arrested. Which of the two parties was guilty of intimidation? The accused or the accuser? It said McCardle hindered Reconstruction for writing against this process. Congress desired that a certain constitution or form of government. Congress? Who's supposed to decide the people's form of government? The people. Oh, we've got to change now, just to let you know. Congress desired that a certain constitutional form of government should be adopted and submitted to the people for their decision, or it was submitted to a portion only of the people of Mississippi. The act of Congress made a show for the expression of approbation or disapprobation, approval or disapproval. McCardle was not among those who were in favor of that Constitution. This was said to be hindering Reconstruction, the commission of a crime which there was a right to punish. No judge who had a clear comprehension of his duty would ask a man to plead to a tissue of absurdities like that. Yet if the trial of McCardle had gone on before a military board, he's being charged in front of a military commission, he would not have had the slightest chance of escape, but would have been convicted. Military commissions never disappoint the expectations of those who order them. Military commissions were always organized to convict. These words were fitly spoken. They were like apples of gold and pictures of silver. He ventured to say that in 9 cases out of 10, military commissions committed outrages of justice and law. Military men, as a general thing, know nothing of judicial duties. Do we have military commissions in the news now?
Yeah.
Here's a treatise, legal writings by the American University of International Law, and it says this. The title of this is written in 2007. It's just a military treatise on military commissions, the forgotten Reconstruction chapter. I'm not going to, for time's sake, everyone will drop this. And here's Mr. Lyman Trumbull. He's the guy voting for the Reconstruction Act. And he says this. Now, is he going to say, hey, they're lawful, constitutional, here's where we have authority to do it? No. He is challenging jurisdiction. The Supreme Court doesn't have authority to rule on it, to hear the case. That's pretty much the entirety of his argument. He said, I shall commence what I have to say by denying the jurisdiction of the Circuit Court under the Act of February 5th, 1867 to hear this case. And if I establish that proposition, of course, the court cannot entertain jurisdiction. He says, I have gone substantially over the ground which I intended to occupy. The propositions I have endeavored to maintain are first, that the court has no jurisdiction in the case because the Act of February 5th, 1867 did not authorize the Circuit Court to take jurisdiction of it. Well, what happened? Does it look like does it look like Jeremiah Black's going to win, or Lyman Trumbull's going to win this? Looks like Reconstruction Act is going to be declared unconstitutional. Good day for us. But what happened? Where's the Supreme Court sit? Washington, D.C. Where's Congress sit? Washington, D.C. Who's the guy voting to keep the Reconstruction Act in place? A senator. So what's he do? He goes back to the Senate and proposes legislation that's going to take away the Supreme Court's jurisdiction to make a ruling on the case. Only case in the history of the United States this has ever happened. This is our Congressional Globe. I pulled up the arguments of where this was discussed, this legislative act. He says, in my judgment, there's no such great importance to this act that's going to take away the jurisdiction of the Supreme Court. It is a bill of very little importance in my judgment, and I wish to say to the senator from Maryland that the Supreme Court has not decided that any case is pending before it under the Act of February 5th, 1867. No such decision has been made, nor do I believe any such decision would ever be made. You know, this doesn't affect anything. There's no case in front of the Supreme Court. Remember, he's legal counsel. He's the one that gave the oral arguments days before. He says, now there is no such case as pending in the Supreme Court. And there has been no such case pending in the Supreme Court. Well, he gets called out by a Wisconsin Senator, Doolittle. Ms. Doolittle says this, Mr. President, my honorable friend from Illinois seems to think that there is no importance in this measure, that it affects nothing and nobody, that there is no case pending in the Supreme Court which this act will affect, that it is a mistake and a delusion on our part to suppose that there is any such case there under the law of 1867. Well, sir, if they be correct in this, why the great haste for pressing this bill? What does it mean? Sir, I apprehend the honorable senator from Illinois is altogether mistaken in the view that he now presents, that this is a very important measure, and that there is a very important case pending in the Supreme Court under the act which is now proposed to repeal. The honorable senator himself, as counsel in that court, if I am correctly informed, with other counsel, made a motion to dismiss a case pending in the Supreme Court or alleged to be pending under this act, and the court refused to dismiss it. We all know, the whole world knows, that this case of McCardle is pending in the Supreme Court, brought up on appeal under the Act of 1867 from the Circuit Court of Mississippi, and that that case has been argued by eminent counsel, and that it is pending. It is important because the case involves the constitutionality of the Reconstruction Acts. It involves the constitutionality of these acts which have been passed by Congress. If there be no such case before the court, why does the honorable senator desire to pass a bill to take away jurisdiction of a case which does not exist? Mr. President, the truth is, and we may as well look it square in the face, it is because men know that these acts will be decided to be unconstitutional. That is the reason why they desire to take away from the court the consideration of the question. And this is out of just a modern law book, giving a little case history of summation at the very end, very last sentence, on the McCardle case. And he says, while the case was under advisement, Congress passed an act taking away the jurisdiction of the Supreme Court as defined by the Act of February 1867 in cases of habeas corpus, and the appeal was therefore dismissed for want of jurisdiction. The bar was thereupon discharged, and no further attempt has been made to test the constitutionality of the Reconstruction Act. That's our remedy. Testing the constitutionality of the Reconstruction Act to change us back from a national government back to a federal government and get this federal government out of our lives. And that concludes the first of 3 parts.